So now is the time when your memorial is ready, when you know where you are going to participate in your moot, when you have your arguments in your mind, but you just need some insights on how to prepare for the oral arguments day. You might be nervous, you might be confident, but you definitely need a step-by-step guide to actually go through it smoothly. This video will help you achieve that guide only. So it will be a 6-step video. I'll be गिविंग यू 6 सिंपल स्टेप्स जिनको यूज़ करके आप ओरल आर्ग्यूमेंट्स को में अपने पूरा स्मूथली सेल कर पाओगे. हाय गाइस, दिस इज ईशा कपूर एंड यू आर वाचिंग VLAWGISH. Tip number 1 is related to real advocacy. So when you're going to present a case in the moot court competition, think like you're actually representing the person. Think like you're actually representing the client and the actual scenario has happened. Talk to people around you, talk to your parents, talk to your friends, talk to any person who's around you, and just let them know about your case and let them know your views on the case. Then if they want to ask questions, if they feel like asking questions, do not dodge their questions, do answer them. That will give you an idea as to what a thought process of people around you can be like, and sometimes thought process of judges can be even similar, although most of the times they're going to ask you questions based on laws and based on facts only, but you never know, hypotheticals may also come your way. Now so therefore I would advise you that you should kind of step into the shoes of the person you are representing. Represent it like it's your cause. Practice several times a day. Do practice with time limits. Practice keeping your watch in hand and make sure that you're never crossing the time. In fact, if you have 15 minutes to present your oral arguments, then you should try and you should plan to complete your arguments in about 12 minutes, because I am sure those 3 minutes will definitely be invested in the judges asking questions and you trying to convince the court, which is also equally important. Now, what all you should keep ready beforehand? Keep a set of judgments that you have used in your memorial ready for reference. Sometimes a judge may ask you as to what part of a judgment that you are referring to, which paragraph, then you should have it highlighted. If the judgment is really long or really lengthy, then you should at least have the first page, the cover page of the judgment ready. Because you never know when a judge might ask you for a copy of the judgment or might ask you the citation of the case, then you should be in a position to provide all that to the court. Along with this, keep a summary of all the relevant sections and relevant legislations that you have used in your memorial ready with you. If a judge asks you, for example, what is section 49 IPC, because you have used that in your memorial, you have used the definition there, then you should clearly know what is that. If you don't know, then you can always pause and you can take some time, take a few seconds and then go through the notes, see your notes once, because there will only be limited sections that you must have used, and then answer the judge. Then you should also keep a summary of the judgments that you have used ready. So make notes on the judgments. You should have the clear facts in the notes in very small pointers. Do not make lengthy notes on judgments. In 3-4 lines, I would say summarize each judgment. If a judge asks you, what was this judgment about? What was the law laid down? What was the concrete point laid down? Then you should be knowing that. Sometimes judges also focus on facts. So do not think that the facts are not important, because especially in a problem which is purely fact based, which most problems are, then the judges might say that the case differ from the case that you are stating. So you should be in a position to justify as to why you have used that judgment or why you want to quote that. So this was the first tip, where I have told you what all you need to keep ready beforehand and what you are actually doing, how you should prepare for the day. Also, take your good night's sleep for good 8 to 9 hours before the competition, because this is something जहाँ पे आपका बहुत ज़्यादा mind invest होने वाला है, and you should be ready for that. The first stage when you begin your arguments is the introductory stage. So how do you introduce yourself? You do not say that, hello, I am Isha Kapoor, hello, how are you, hello, how have you been doing? Do not use such words if you are in a court. Therefore, you should go there, but you should definitely introduce yourself. So what are you representing? What are you, in what capacity are you there? In what capacity are you standing in the courtroom? For example, you can say, may it please the court, I am the counsel for the appellant, or I am the counsel for the respondent. This will be your introduction, which is good enough to begin with a moot court competition. For example, if the judges ask you, how are you, Mr. Counsel? How are you, Miss Counsel? How have you been? Do not answer in phrases like, I've been amazing, I'm feeling great, I'm feeling fantastic that I'm a part of this moot court competition. Remember that you are an advocate, you are in a courtroom, and you are in a mood where you are the officer of the court, and you need to get the interest of your client sorted. Also, many people had this confusion as to how to start with the argument phrase. What is that actual line? So I've told you the line where you need to use, may I please the court. Then if you want to start with the arguments, then you should always ask the permission of the judge. So you can ask them that if you are well versed with the facts of the case, the counsel would like to begin with the arguments and the issues and the arguments. So the line is, if your lordship, or if your ladyship, or if the bench, or if the court is well versed with the facts of the case, the counsel for the appellant would like to proceed with the issues and the arguments. The judges may say that, okay, you can proceed with the issues and the arguments, the first issue and the arguments, or they may say that, no, we would like to know the facts of the case. They usually do not ask for the facts, but they might ask. There is a 50-50 chance, you can say. So you should prepare the facts beforehand. आपको एक छोटे से पैराग्राफ में फैक्ट्स में ज़्यादा टाइम मत इन्वेस्ट करना कभी भी. आपको 3-4 लाइन में अपने फैक्ट्स प्रिपेयर करके रखने हैं, ताकि आपका कम से कम टाइम वहाँ जाए और आर्ग्यूमेंट्स में ज़्यादा से ज़्यादा. फैक्ट्स को इस तरह से रिप्रेजेंट करना कि वो भी आपके क्लाइंट के फेवर में हो. आपको बिल्कुल भी किसी फैक्ट को मोल्ड नहीं करना है, बट योर वे ऑफ स्पीकिंग और योर वे of conveying should be such that the judge is attracted towards you and feels like listening to your case, feels like listening to your side of the story. The third step in preparing for the oral argument round is relating to the conversational style that you should use. Remember that you and the judge are both officers of the court, and you are sailing in the same boat. You both want justice to be rendered to the deserving party. So, and what you're doing is, like, you are presenting a story based on facts, based on laws, and of course based on case laws, based on decisions that have already been given by the courts. So it is natural for a person who is listening to your story to ask a lot of questions and queries. And if the person is asking you a question, then it definitely goes in your favor, because it shows that the person is trying to understand, or at least understanding some part of the arguments that you are trying to make. So if a judge asks you a question, and for example, if I am a judge and I start asking you a question, then what you should always remember is stop when the judge starts speaking. Okay, pause for a minute, come out of your zone and try to understand. Listen carefully to what the judge is trying to say. He might be trying to raise a very valid point. Then whenever the judge finishes asking that question, thank him for raising a point, and make it seem like, and you should always be very grateful for, you should show like it is very grateful of you, and you want to thank the judge for raising such an important point, which is also of a major concern or a great concern to you, to your case as well. Then sometimes it may happen that a judge informs you something that you do not know, or a judge corrects you at some point, maybe at a simple error. Then you should not just say sorry and then move on to your next arguments, or you should not just ignore that comment and move on to your next argument. You should say that you are really grateful to the court for highlighting that part and for assisting you in the case. Next point is about your hand movements. So if you know that you have control over your hands, then definitely use your hand movements to assert your points. It will be an add-on to your presentation skills. But then if you think that the remote control of your hands is in the hands of God and is not in your hands, and your hands may even go on and point the judge at some point, or you might get really angry and your hands might show that, then do not use these hand movements. Keep them still. Okay. Then how to start your arguments? You should always, to make sure that that this goes in a conversational style, you should always start your arguments with a catchy line that holds your judge's attention. Now, once he's hooked, he will try to listen to your complete story. You should present that story. You should plan that story beforehand, and you should present that in bits and parts, and those bits and parts will be your issues. So you should connect all your issues. Always remember that in India we normally refer to judges as, if there are more judges, then we call it a bench, the court. You can refer to them as lordship or ladyship. Then I have observed such scenarios where some judges do not like addressing them as the lordship or the ladyship or your honor. In that case, you may use words like sir and madam as well. Fourth point of presentation is very important, and it is related to addressing questions. Often we prepare the whole speech, the whole issues and the arguments, but we do not know how to address the questions. A judge might start asking you questions at the very beginning stage. For example, there might be a question like, the judge may say that, Mr. Counsel, Miss Counsel, I feel like that the FIR was filed after a gap of 3 days and there is definitely a delay. Then thereafter you should pause. You should think for 10 seconds and then only answer. सबसे खराब चीज़ जो हम कर सकते हैं वो है बिना क्वेश्चन को समझे या फिर बिना सोचे आंसर करने लग जाना. 10-20 सेकंड के लिए अपने माइंड में एक छोटा सा प्लान बना लो. उस प्लान में होना चाहिए कि मुझे इस क्वेश्चन का आंसर येस देना है या नो देना है, और अगर मुझे येस या नो देना है तो मुझे रीज़न देना है. क्या रीज़न देना है, वो कितने रीज़न होंगे, और फ्रेजेस कुछ इस तरह से यूज़ करो जो कि कोर्ट को कन्विंसिंग लगे. फॉर एग्जाम्पल, स्टार्ट आंसरिंग बाय फ्रेज लाइक, if you want this answer to be a no, then you should say, no, your lordship, the counsel do not feel so. That position won't be correct to assert, and I assert this because of the following 2 reasons. Then start saying your 2 reasons. You can say the respondent was not in a fit state of mind, and secondly, the FIR was filed after 2 days, that is as soon as the respondent recovered from the hospital. So what you are doing is you are explaining about that gap. You are explaining why the delay was not inordinate and why the delay was condoned and can be condoned at this stage also. So basically you should have a plan in mind for answering the questions also. Then the second kind of question that comes from judges can be on the facts, on a case law, on a judgment, or on sections. For example, if you don't remember something, and if you commit an error, that might be a small error as well, politely tell them, as I told you earlier also, that you're grateful for their assistance and their insight on the position. Don't worry, they won't judge you. They don't want you to be and they neither expect you to be an encyclopedia on the case or to act like an encyclopedia of the laws. Sometimes they might ask you out of the box questions as well, like on different legislation. Then you can say that you can just plead ignorance there. And there might also be a situation like where you do not understand the question, सुना नहीं, रह गया. तो आपको कैसे करना है? आपको बोलना है कि your lordship, if I understand the question correctly, then your lordship is trying to make the point that the FIR was delayed because there is a gap of 3 days after the offence occurred. तो इस तरह से आपको बोलना है कि अगर मेरी समझ के हिसाब से आप शायद ये कहना चाह रहे हैं. इस तरह से आप क्वेश्चंस को एड्रेस करेंगे. The fifth point that you keep in mind while preparing for your oral arguments is how your demeanor should be. The demeanor starts from coming into the courtroom and standing right there on the podium. On most occasions, you have a podium there. Always remember that please do not lean over the podium. Do not put your elbow like this on the podium and your hand on the cheek like this, your fingers on the cheek. Do not look at the judges like this when they're speaking, no matter how beautiful or how handsome they might be. Do not ever shout or get angry. Remember that to prove your point or to raise a concern, your voice should not be so high. A judge will hear you only when you are respectful and you are using your voice tone in a moderate manner. Keep the tone low but high enough to make it reach the judges. Then always remember that voice modulation is important. Do stress on the points you want the judge to definitely hear. Do stress on those arguments. You can always repeat them as well, but do not repeat the point more than twice. Okay? Be assertive. Use expressions. Do not look like a blank page. A judge will only be interested, the conversation, the story will only move forward when you are both steering it using all the things. I mean, you have to use the gear also, you have to drive well, you have to look at the side mirrors as well, and you have to keep an eye on the back also. You don't want to be involved in an accident basically. So remember that you keep the conversation going. Also remember that when the judge is speaking, listen and understand. Whenever the judge is speaking, don't say words such as, oh, that's right. I was thinking the same. I agree with you, my lordship, your lordship, or yes, you're absolutely correct. Yes, that is an amazing point. Do not use such words. Also, please know humor. You don't know the judge doesn't know you. Maybe आप दोनों के humor levels match ना करते हो. अगर वो humor levels match नहीं करे तो वो humor कई बार judges के लिए disrespect भी हो सकता है. Why I say humor is not necessary? Because nowhere in your case, if your case is not like that, nowhere in your case it is required that you should use the humor. ना ही उसे यूज़ करने के कोई मार्क्स मिलने वाले हैं, ना ही आपके क्लाइंट को कोई बेनिफिट होने वाला है. तो आपको अपने क्लाइंट के शूज़ में स्टेप इन करना है. ना ही क्लाइंट चाहता है कि आप वहाँ पे कोर्ट में हंसी मजाक ज़्यादा करो. ये कोई रियल लाइफ कोर्ट नहीं है और ना ही वो ज़रूरत है. बट डेफिनेटली अगर आपको कुछ सिचुएशंस में लगता है कि यहाँ पर ऐसा हो पा रहा है एंड द कन्वर्सेशन इज गोइंग इन अ रियली नाइस मैनर, देन डू इट. Then how to address your opposing counsel? Always address him or her or them as the opposing counsel. Even if the opposite counsel has misquoted something or even a fact, be respectful and only in a respectful manner highlight that correct position before the court. Say that I believe that my opponent has, or the opposing counsel or the counsel for the respondent has misquoted this fact and I would like to clear this before the court. Be very respectful. Do not look like you're just trying to highlight the mistake of the other person, because at all times you should be an asset to the court in actually coming to a decision. So you are just assisting the court in everything that's going wrong there. Then keep asking for permissions. If you're about to move from your first issue to second issue, ask for permission. If you're about to move to another argument, ask for permission. If you want to move to the closing statement or the prayer, ask for permission. The last part of your oral argument round is the concluding statement. So keep your concluding statement very short and concise. Just plan it beforehand. You should always write it down somewhere that what your closing statement exactly is going to be. That can be something like, so that concludes my submission for the day. I plead before this court to affirm the lower court's decision and to convict the accused. Then just conclude with a question that may I be of any further assistance to this court. That means that you are open to any more questions if the court is still not satisfied or wants some insight. Then sometimes the judges may ask you to read the prayer clause. Then you can always read that as it is. Okay, just stand. All the three members of your team should stand there, should raise on the position that they are at, and you should read out the prayer to the court. That will be fine, but always plan it ahead of time. In the end, I would just like to say that you should practice numerous times. You should practice with your opponent. You should not opponent, you should practice with your team member. You should practice before your friends. You should practice with your researcher present there. Your researcher should ask you numerous questions, and also the three members of the team should be trained in a way to communicate from your eyes. If a judge is asking you a question there and you do not know the answer to that, then the researcher in your team or the other member who's sitting there must be quick enough to write something on the chit and pass on that chit to you to help you in how to address the question. So you know that somebody is there for you. So it will be like I have your back kind of a situation. And always remember that the team is everything, and if you people support each other, if you have faith on each other, then your competition will definitely go really well. All the best for it. If you haven't watched the video on how to prepare the Moot Court memorial, then just go and watch it. Watch the series on the Moot Court competition. I hope it is helping you. So this concludes this video for today. I hope you liked the video, and I know if you like the video, if you have watched this video, you'll definitely share it with your friends. It means a lot to me. Thank you for watching all my videos. Thank you for showing so much love. Please comment down below as to what you feel about this video and what all new videos you want to see. Till I post a new video, I like to say bye to you all.